For judgment item number 1, TREV1 of 2001 and batch of matters.
So on the canteen sales, we've not sent it back because there is not enough material. On the other two, that is supplied to contractor, the hiring charges from contractors and from interdepartment use of machinery, that we've sent it back to the AO. So the revision petitions are disposed. Gratefully.
I agree.
For judgment item number 2, WPC 13508 of 2010.
So we've awarded 10 lakhs as compensation for the custodial death. That is both CRPF and the Odisha State Police. They're jointly made liable to pay this. If you don't pay it within 8 weeks, you will pay with simple interest at 6% for the period of delay. And I've asked for a compliance affidavit to be filed in the court.
For judgment item number 3, WPC 13736 of 2017 and batch of matters.
As regards invocation of power under section 7.5 is concerned, there is sufficient cause for non-payment of tax. So we have quashed E24, but we have relegated you to avail appellate remedy in respect of assessment orders. And simultaneously, we have directed you to deposit 2/3 amount which was not paid on account of interim orders operating within a period specified, and interest on that for the period 10 to 2017 as a compensation you have to pay at simple interest 9% following Supreme Court judgments.
Good. This will be uploaded today.
Yes.
Judgment item number 4, WA 239 of 2018 and batch of matters.
We have allowed the writ petitions. The judgment of the learned single judge is set aside. It is made clear that vehicles which were registered prior to 21st November 2017 would fall under the optional clause and would not be required to compulsorily pay the one-time tax.
For judgment item number 5, ITA 39 of 2022 and batch of matters.
The appeals have been dismissed.
We expected many such judgments from your bench notes.
Yes, it's available.
I have a complaint, but I have take instruction within 1 week, my lord. Already comply, they have filed the affidavit.
On 27th of February 2023, that affidavit must be.
Affidavit received, my lord.
Opposite
They have
party.
already complied, my lord's order. I pray for my 1 week time, my lord, to take instruction the petition, whether the public road is vacated or not.
As we have given photographs also, the encroachments had been removed.
If it is not, you file an application, sir.
Yes.
An affidavit dated 27th February 2023 has been filed. by the Sub Inspector of Police, Shahid Nagar Police Station, Bhubaneswar, giving details of the progress in Shahid Nagar PS case number 502 dated 2/12/2020. So it is stated that in the said case, two accused still remain at large, and an NBWs have been issued under the orders of the JMFC 3 Bhubaneswar by order dated 4th February 2023. Full stop. Charge sheet has already been filed in CS number 76 of 2023. Dated, the charge sheet has already been filed on 16th February 2023 against the accused persons. Full stop. It is further stated that there is at present no encroachment on the road in question. And photographs have been enclosed with the affidavit in proof thereof. Paragraph. In view of the above affidavit, no further directions are called for in the present petition. So if the petitioners find that any part of the above affidavit contains an incorrect fact, it will be open to the petitioners to apply to the court for directions. The petition is disposed.
Great offense, my lord. Supplementary list item number 5.
There's item 5 pertains to regularization of daily wage workers. My lords, all those matters are posted to 24th of April. As there are about, as I'm giving the list, item 5, item 6.
No, item 6. Item 6 is, my lords, item 6, your lords, you have posted to 23/3/2023, my lords. It's a contractual
That's a
matter, my lords.
There's item 5, item 52, 66, 67, and 75. Those are.
These are for 23rd April.
No, my lords, this is 24th April.
24th April. All right.
With writ appeal number 137 of 2022.
All right. List on 24th April with
137 of
137 of 2020. All right.
Item 60 and 70 are also the same matter in the same batch.
All right.
Item number 6.
So far, item number 6 is concerned, my lords. Your lordship have posted this matter to 23/3, my lords.
List on 23/3. All right.
And item number 8, my lords. So far, item number 8 is concerned, my lords. 8 and 24 and 38 and 43. Your lordship have posted this matter to 29/3, my lords.
8 outsourcing.
Outsourcing matter has been posted on 29/3.
29.
I'm giving the list 8 पढ़ूंगा देख. हाँ 7 से.
But don't make a mention on item number 59. I'll tell you.
Great, my lords.
All right. All right.
May call.
Item 6 is now 23rd.
Item
Yes,
6,
my lord.
23rd
Item
March.
6 is on 23rd, my lord.
Item number 7, please.
Because item 7 is, my lords, the Sarat Parida case. My lords, it's fixed it to 8th of May.
So list on 8th May, 7.
Item 8.
8 on 29/3, my lords.
Item number 9.
May I please, my lord. My lord, herein I'm challenging one order dated 23 of February 2022 passed by Honorable Single Judge. Herein, my lords, before pressing my matter, I may be permitted to submit the summary of the case. What has happened? One arbitration proceeding was going on before learned sole arbitrator. Therein an award was passed against me, my lords. Thereafter, the present respondent has filed an application under section 33 for correction of arithmetical error. therein, my lord, another prayer was made for reconsideration of evidence stated before the learned sole arbitrator. Honorable arbitrator, while considering the section 33 application, Malas corrected the arithmetical error, but while reappreciating the evidence content in the claim statement, he has stated that it would be amounts to review. Thereafter, a writ petition has been filed by the present respondent.
How is a writ petition maintainable?
Yes, Malas, writ petition is not maintainable,
I know.
Malas.
You say notice, there should be a stay of the impugned order.
Malas,
This order was passed when?
this order was passed in 22nd of February, my lords.
It's more than a year
20
ago.
Yes, my lords.
What has happened in the 1 year?
That's why, my lords, I have asked for a permission to submit the summary. Thereafter, in furtherance to the order, my lords, learned sole arbitrator has reappreciated the evidences and passed another award against me, my lords.
Then this is infructuous. You say,
No.
in view of the fact that pursuant to the impugned order of the learned single judge,
My lords,
the arbitrator has already passed a fresh award. The present petition appeal has been rendered infructuous and is disposed of
My
as such. It will be open to the appellant if the award is against it.
my lords,
Is the award against you or
against me, my lords. What I
to raise all pleas, including the pleas raised in the present appeal, while challenging the said award? All right.
my lords, what I submit, my lords. If my lords, my lords may admit this matter and direct for the learned arbitrator to recall his order, then it could have.
Also, we'll compound the same problem, sir. Once an award is passed, the arbitrator becomes functus officials. There's no question of asking him to do all that.
I understood, my lords. Highly obliged, my lords. My lords, I may be given the liberty to raise all this.
You have not heard the order, sir. I'm not going to repeat it.
Pardon me.
Item number 10.
Obliged, my lords.
Item 10, your lordship, fixed it to 10, 20.
No, don't multiply now. Only one by one. Item 10, tell us which date.
Yes, well, I'm saying that your lordship fixed it to 23rd
23rd of?
March.
10 is 23rd March.
Item 11.
23rd March.
11, 23rd March.
Right.
Item number 12.
That's item 12. Here, my lords, the respondent was convicted under section 13 of the Prevention of Corruption Act. Now, my lords, in the writ petition, it was argued that since the sanction was not given by the authority, therefore the conviction is bad and hence he should be reinstated.
But that they have not appealed against the
Yes,
conviction.
my lords, there is an appeal pending, which is
I see.
so
Got it. Say notice return
grateful.
14th August. There shall be a stay. Delays condoned. There shall be a stay of the impugned order till then. All right. Great.
I'm appearing for the rest.
All right. She accepts notice. All right.
For orders, item number 13.
May I please? My lord, the petitioner challenges the allotment of 80 acres of the government land for a red category of plant cement factory, violating the eco-sensitive zones of 10 kilometers as fixed by the...
See, you can go to the NGT for all this, sir.
My lord?
You can go to the NGT for all this. Permitting the petitioner to approach the National Green Tribunal. In accordance with law, the present petition is disposed of. All right.
My lord, what I submit, my lord, the industrial unit cannot be set off as per the IDCO Act, my lord, because the land is not, the area is not notified, my lord, by the government. And the same is also covered by the judgments of our own High Court, my lord.
I think the point you were making earlier has nothing to do with this point.
My lord, as per the Odisha Industrial Infrastructure Development Act, my lord, the area must be notified by the government for the industrial setup, my lord.
What is, see, para 16 of your writ petition, just come. So you are saying EIA notification, they should have called all of you for participating in the hearing, correct?
My lord. My lord, unless the area is notified, my lord.
No. The whole petition is about the EIA hearing.
My lord. My lord, the
red category industry.
My lord, red category industry. My lord.
affecting wildlife, habitat, flora, fauna.
My lord.
All this is NGT, sir.
My lord, that apart, my lord, my submission before your lordship that the area is not at all notified by the government as
That's all right.
required.
That also,
required
the NGT can examine all that. Sir. That the NGT can, this incidental to this main point of affecting the environment. All right.
So, my lord,
Item number 14.
Yes.
Item number 14, my lord. Petitioner
9.
Petitioner praying before your lordship to direct the opposite party number 2 to direct his officers, opposite party number 3 and 4, not to construct the Anganwadi building and not
All
to
right. We'll
violate.
say the petitioner's representation, bracket annex 3, shall be examined by the collector Khurda and after notice to the petitioner and to opposite parties
3 and 4.
3 and 4.
Yes, my lord.
No, where?
Opposite number 2 is a collector, my lord. Opposite number 3 and 4 is a Tahsildar and BDO, my lord.
We don't need notice to them, sir. Which is the entity, opposite party number 5, you say. And after giving them a hearing, a reasoned order shall be passed not later than 15th May and be communicated to the parties within a week thereafter.
Oblige, my lord.
The court clarifies it as not expressed in the matter.
Oblige.
Item number 15.
15 my lord has to file an affidavit. I received detailed instructions yesterday. Short accommodation, I'll file. 10 days time.
Counsel for the CMC assures the court that an affidavit will be filed within 10 days. No, but what's the position on this?
My lord, substantial work has been undertaken. I have those details. I mean, there's huge details. Electrical works, toilets, sanitation, drainage, everything.
Your Lordship, by next date, I will also file counter photographs also. Liberty may be given.
Yes, that was. It will be open to the petitioner to file a response thereto for the next date. List on 4th April.
Obliged.
Deeply obliged.
Item number 16.
Maybe yes. My lord, the limited grievance of the petition by lord seeking for a direction to the opposite party number 3, that Tahsildar Kujanga, to dispose of the encroachment case. Because the encroachers unauthorized encroach the land where and covered the safainar, for which the flow of discharge of water has been is blocked. So only the limited grievance that the
come to the cost title of the matter, sir.
Mild.
So was from the cost title.
Mild.
You have the cost title, sir. You have the cost title.
Mild.
Come to the opposite parties.
Mild.
You have the opposite parties, sir. Opposite parties in the cost title you have.
Yes, we will have.
How many opposite parties?
5 opposite parties.
Which of them is the encroacher?
Opposite party number 3, Tahsildar.
Tahsildar is the encroacher.
No, Tahsildar has.
Which of them is the encroacher?
Encroachers is as per the opposite party force report.
You have not made them parties. Have you made them parties?
No, the encroachers has not been made as a party.
They should be made, sir. They should be made parties. Have you named them in your representation?
No, that name is not only on the basis of our representation. This encroachment case has been initiated, but the notice has been issued. But we have not details of all the encroachers.
You have to find out, sir. You have to find out, and you have to make them parties. Counsel for the petitioners seeks leave to withdraw the present petition with liberty to file a proper petition in accordance with law. Disposed of is withdrawn with liberty is prayed for.
Item number 17. Item 17.
Pass over.
Item number 18.
May I please, your lordship? Defects I have removed, my lord, no defects. My lord, limited grievance of the petitioner that there has been encroachment of public by the adjoining landowners, and for redressal of our grievance.
So show us the number of which opposite parties are the encroachers, sir? Come to the cost title.
My lord, I have not made opposite parties. I may be granted leave to add them.
The petitioner seeks leave to withdraw the present petition with liberty to file a proper petition.
Obliged.
Disposed of withdrawn liberty spirit.
Item 19.
May I please your lordship, my lord? The order which is challenged, my lord, in the appeal is at page 22, my lord.
Yes.
The order has been passed, my lord, directing to regularize the petitioner in the writ petition. My lord, the petitioner in the writ petition before your lordship, my lord, he was engaged under the appellant corporation on deputation basis. And taking the ratio of the Uma Devi case, my lord, he has been directed
19.
19, my lord. And in the meantime, my lord, what has happened? The respondent has retired from the service of the corporation, my lord, because he was repatriated to the original department, and there
So nothing remains in this matter.
Nothing remains, my lord.
Counsel to the petitioner states, the appellant states that in view of the subsequent developments, the present appeal has been rendered infructuous, is disposed of as such.
And
Item number 20.
This matter may be yours, 23rd.
All right.
Item 21.
in 19, my lord, your lordship may indicate that because he has retired from service.
All that we don't.
Otherwise, he will may claim something. my lord.
Let's see when he claims.
My lord.
21.
21 my lord, sort of product is 8th May.
8th May.
Notice
Item number 22.
22 may be posted to 29th of March 2020.
Item number 23.
23 sort of product.
8 May.
And giving the copy my lord that notice.
Item number 24.
24, my lord, your lordship are pleased to fix this matter on 29/3, my lord. In the meantime, let them serve me a copy of the picture.
Item number 25.
25, I may permitted to withdraw my lord with liberty to file a review. Giving
Same
the
order.
my lords.
Liberty to withdraw, liberty to file. Review. 26 also same thing.
26.
No, my
Oh, as 26 may be passed over.
All right.
Item 27.
As 27 is my lords have posted it to 30th of August 2023.
All right.
The rehabilitation is
30th August.
Item 28.
28 my lord, departmental proceeding during pendency of the departmental proceeding, direction promotion has been given for promotion. The lordship has fixed similar matter to 27th March.
27.
Are you agree?
Item 29.
And 27. 29 my lord, your lordship fixed it to 23rd March. That has been fixed to 23rd.
Item 30.
30 also 23rd March.
Item number 31.
That is also 23rd March.
Item 32.
and 32 is my Sarat Parida case. It is 8th of May.
You're right.
Item 33.
Item 33, my lords. Original application was filed before the tribunal for regularization of service. My lords, that was filing a writ application. It was got transferred to the High Court. My lords, thereafter it was taken out and dismissed for non-prosecution because the council said that I have no instruction and the petitioner taken that file. Thereafter, a CM appeal filed back. It was because of a misunderstanding. But that CM appeal was dismissed. But thereafter also the counter and rejoinder, everything was filed. The case is ready, my lords. The petitioner worked for more than 30 years. I pray, my lords, an adjudication on merit of the matter. Purely a miscommunication, my lords, communication gap.
What is happening now?
Lords,
No. What was your plea? Original plea? Regularization.
Original plea is regularization. Serving 27 years of service and
All right. Notice returnable. Third May. 3rd May.
Item 34.
Serving notice, my lord. Serving, I have to serve the notice.
I said notice returnable 3rd May.
Item 34.
34.
Here, government is the party, my lords. I will serve copy to the government, my lords.
Whatever, sir.
Item 34, my lord, that departmental promotion during pendency of that departmental proceeding, similar to item 28, I have given that copy.
27th March.
27th March.
Item 35.
That's item 35 may be taken up on some other day. So I'm asking for a short adjournment. There's another matter, my lords. There are two matters.
At the request of counsel for the appellant, 17th April.
Item 36.
29th March, my
Item 37.
37. 37. Outsourcing, 29th March.
Well, let's this 29th March 2020.
Item 38.
This is 29th March.
Let him serve me a copy, minutes.
Item number 39.
39 also 29th March.
Item number 40.
40 that during pendency of departmental promotion, that item 27th March was fixed.
Item 41.
41, I may permitted to withdraw that writ appeal with liberty to file a review appeal.
Permit to withdraw with liberty to file review.
Item 42.
At 29th March.
Item 43.
29th March.
Item number 44.
That is also 29th March.
Item number 45.
45, my lord. The 1 day disposal, your lordship pass order in similar matters.
Disposable.
Same date, all same dates.
Item 46.
46, my lords, may be posted to 30th of August 2020.
Correct.
Item 47.
That's 47. I'll seek instructions whether it has been implemented, because the judgment on which it's relied that we have implemented, that is for another municipality. This pertains to Miller's retirement age. I'll seek instructions if it has been implemented.
18th April, at the request of counsel.
Item 48.
48, my lord, 23rd March.
Item number 49.
40. May I please? Similar matter, your lordship has passed the interim order on this petition has been filed by the association, that was the individual petition. Next. I'm giving the next.
Which is the next date?
I am giving.
All right, same order is returnable, that date which he gives, list along with 810/2021. Writ appeal number 810.
Item number 50.
50, I may permitted to withdraw my.
Or with permit to file review.
My.
All right.
Item 51.
51, my lord, 23rd March.
Item 52.
It's 52 is my lord's 24th of April.
Item number 53.
53 may be passed over.
All right.
Item 54.
54, my lord, 29th March.
Item number 55.
55.
Yes, 55 is 30th of August 2023. Rehabilitation.
Item 56.
56, my departmental proceeding during pendency of department promotion. That is 27th March.
Item 57.
57, you also pick that item 35, you also pick both the matters. 35.
Okay. 57, same as 35.
17th April. Item number 58.
Under 58, the matter has become infructuous.
All right.
I may be permitted to withdraw. I have filed the memo.
Memo taken on record, disposed of.
Item 59.
So 59 is concerned Millets. It is a case of regulation Millets in respect of the colleagues of the petitioner Millets. Your lordship are already pleased to pass orders. Your lordship dismiss the writ appeal Millets. Your lordship may kindly.
What has happened in this case, your lordship may turn to page 59 annexed 2.
But they have not served me a copy of the writ appeal Millets. But your lordship may kindly see the order Millets that I am giving Millets.
Your lordship may see page 59.
Yeah, but SLP has already been dismissed.
Yes, my lords. SLP has been page.
Let me complete.
Okay.
Your Lordship, see page 59. In this case, he has relied upon that order part in 1995 of 2020. That is under challenge in 777 of 2021. Your Lordship has fixed it to 25. And in fact, he is not covered by that judgment. He is not covered by that 1995.
When is it listed?
The 23rd, my lord.
23rd, okay.
Your Lordship, kindly see the page number 1. Your Lordship, for a moment, kindly see page number 1, my lord.
Yes.
Page number 1 is similarly situated.
I don't dispute. You are not covered by 1995.
No,
you are not covered by that judgment.
Your Lordship, kindly see the page 2. The order has been implemented. Page number 3, my lords. In it's their post was total 14 posts, my lords. Out of 14 posts, my lords, everybody has been regularized except for this petitioner, my lords.
I am not.
Yes, your Lordship, kindly say that this may be allowed in respect of those petitioner, my lords, and that 19951 shall not be.
May I submit? Your Lordship may clarify that he is not covered by this judgment and he is covered by another judgment. Your Lordship may say that.
Yes, your Lordship may.
This order has been passed by that covering that judgment which is under challenge.
Your Lordship may only say that I am covered by at page number 1 that I have given, my lords. I am covered by that order. Your Lordship may pass similar order, and your Lordship may also be pleased to clarify that this may not be a precedent in case of 1951.
Let him take instructions, sir. List on 23rd.
Right.
All right.
I don't know, 60.
But 60 DLR, your Lordship fixed to 24th April, man.
All right.
137 of 2020. Readable 137 of 2022.
All right.
Item 61.
61, my lord, sort of product. 8th, my your Lordship fixed to 8.
Right.
Item 62.
62.
62.
62 the state. 60 state of Odisha, Girish pass over.
62 may be passed over the file.
All right.
Item 63. Item number 63.
OPSC.
63 my OPSC.
They were different houses.
They have different houses. We are not appearing.
All right. Pass over.
Item number 64.
As item 64, well, as here, the respondent wanted to apply for a post at AIMS. He had joined as assistant professor at SCB Medical College. Now, for that, an NOC has to be granted. Now, the government denied the NOC. Therefore, Millards, he approached this honorable court. Now, the impugned order relies on another order of Dr. Snehalata Malik versus State of Orissa, where Millards, one particular rule has not been adverted to. Therefore, Millards, the court said that you cannot not give the NOC. Now, that Millards, that rule, Millards will find at page 76, because there is a dearth of doctors, specialists. So, therefore, Millards, persons holding permanent post, Millards, to be posted elsewhere, Millards, their application will not be forwarded. That is what the rule says. Page 76, Millards, Rule 5.
Yes.
Forwarding application of permanent and temporary government servants. No application of a government servant who holds a permanent post in the office in which he is working or who is likely to be made permanent in the post held by him or in any other post in the office in which he is working shall be forwarded by the appointing authority for his appointment to a post elsewhere. So, Millards, this has not been noted, Millards, in that judgment. And therefore, Millards, the error has crept. And currently, Millards, the respondent has been promoted as an associate professor, and he's posted at the Government Medical College, Keonjhar. So he's in service.
No, the impugned order is 12/2/21, 2 years ago.
Please, Millards, he was posted at the Government Medical College, Keonjhar, around 24/2/2022.
No, have you implemented the impugned order or not?
Is the impugned order? No, my lords, it has not been implemented.
No, this interview he has appeared now subsequently or what?
No, my lords, unless he gets the NOC, he won't be able to.
No. So now it's held to be, you're not granting a NOC, is held to be unconstitutional.
Please, my lords. My lords,
You've been directed to issue NOC to enable him to appear for the interview.
Please, my lords.
This was long ago.
Please, my lords.
So now all that must be over, sir. Why are you arguing this? Long ago, this writ appeal never came up for hearing. There's no stay granted.
No, it's not.
Then that's the point, sir. The very subject matter is all over. But the impugned order, a direction has been issued by the single judge to the present appellant to issue NOC in favor of the respondent to enable him to appear. In the interview for the post of faculty at AIMS Bhubaneswar, pursuant to an advertisement issued on 13 November 2020. Within 7 days of the receipt of the copy of the judgment. Paragraph, the judgment was delivered more than 2 years ago. The interview for the said post must have been also concluded long ago. With the subject matter not surviving, the court sees no reason to interfere. The writ appeal is disposed of.
Item number 65.
The item 65 posted to 29th of March 2023.
But I have instructions to appear in this matter, my lord, and name may kindly be reflected. I have instruction to appear for the respondent, my lord. My name may kindly be reflected.
Item 66.
66, my lords, is a DLR matter. My lords has posted it to 24th of April.
24th April. All right.
Item 67.
67 also, my lords, 24th April.
Right.
Item 68.
68, my lords, is rehabilitation assistance, 30th of August.
Item 69.
69 वाला शर्त पड़ रहा है.
8th May.
Item 70.
The DLR matter, your lordship, fixed to 24th April, my lord.
Item 71.
My lord, item 71 and 72, both the matters are identical. The lordship kindly granted me 2 weeks time. I file short amendment. It is in prayer portion, it has been wrongly typed. I have to file short amendment.
Counsel, the appellant seeks an adjournment to prefer an application for amending the writ appeals. At his request list on 18th April.
Item 73.
73 my lord, शर्त पड़ रहा है.
Item 74.
May I please? 74, my lord.
70.
May I please, my lord? My lord, as per the NHAI rule, the minimum distance between two toll plazas shall be 60 kilometers. But here the NHAI authority flouting the rule are placing the toll plazas within 32 kilometer, 59 kilometer, 42 kilometer and 42 kilometer, my lord. Here, my lord, being prima facie satisfied, the Honorable Single Judge pleased to pass interim order. Thereafter, the counsel for the NHAI appeared and said that already the toll plaza installed and per day they are losing 16 lakh rupees, which is not a fact. And Honorable Single Judge also ordered that the documents of the vehicles to be deposited by before the toll plaza. But till yet, the toll plaza has not yet started.
So no grievance. You don't have any grievance then?
Yes, my lord. It is for also for the interest of the general public, my lord. Because the toll plaza distance shall be 60 kilometers. But here, flouting the rule, what they are doing in 32 kilometer, in 42 kilometer, in 42. So, my lord.
So nothing that you say the toll plaza is not functioning. Nothing is being collected.
My lord, thereafter, after disposal of this writ petition, the toll plaza started functioning, which is only down distance of 42 kilometers. My lord, only I want to draw your lordship's kind attention to page 5 of my writ petition. There I have given the details of the distances. 60 kilometers there it is mandatory because it is the NHI is taking tax, my lord, which is not permissible under law, my lord. Yes. In one case, it is less than 60 kilometers, all right. In every toll plaza, the rule clearly says, and the project appraisal committee, can the project appraisal committee override the statute, my lord, without giving any concrete decision?
No, what was the single judge's order? Let's see now.
Pardon, my lord. The impugned order, my lord. Running page number 44, my lord.
5 truck owners.
Yes. 5 truck owners, 27 vehicles. The Honorable Single Judge pleased to observe that they have not filed their documents. But what the Honorable Single Judge pleased to pass order? Deposit the documents before the toll plaza.
No, but have you gone under Rule 9?
My lord, Rule 9 I can avail, my lord. But they have flouted the law repeatedly, my lord. Why not 60 kilometers? See, one case it is not 60 kilometers, all right. That's why I want to draw your lordship's attention to page 5 of my writ petition. That only I want to place, my lord. Page 5 of my writ petition. That in a box I have given the detailed distance, my lord. That is my only grievance, my lord. And my lord,
what is in monetary terms? What does it work out to, sir?
Yes, my lord. Monetary terms, page 6, my lord. Page 6 of the writ petition. I have given the toll plaza at Hassanpur, it is 400 for truck. Then at Khantaghar, it is 250. And at Bonnajodi, it is 400. The illegal levy of tax, my lord. In one case, it is all right, I should not the place. But in each and every toll plaza, that is not in proper distance, my lord. They are looting for general public, my lord. That is my humble submission.
At the time of the single judge's order, the toll plaza was not functioning.
Yes, that was not functioned. But the council appearing for the NHS said that they are losing 16 lakh from per day. How they calculated it? That was my submission there, my lord. And I was directed to deposit my documents before a toll plaza, which was not functioning. No people was there. Only after vacation of this interim order, the toll plaza started functioning.
Or at least a notice returnable. 6th April.
My lord.
Item 75.
The 75 is 24th of April, DLR regularization.
Item 76.
State is the appellant. 76. State is the appellant. There is a delay. The order was passed on 30th April and we have filed the appeal on 30th March 2021 and we have filed the appeal on 25th April 2022.
Anyway, delay is one part. What is the matter about?
This is all within the COVID period, my lord.
No. What is the main matter about, sir?
Yes, my lord. Yes. Lordship may kindly see the impugned order is at page. The Honorable Single Judge, there are 2 prayers of the petitioner before the Honorable Single Judge. And one prayer was rejected, another prayer was allowed, which is impugned before your lordship. That your lordship may kindly see paragraph 5. Mr. Misral on a day.
You've only been delegated
yes,
delegated. The Board of Revenue, that's all.
Yes, delegated.
Let it be, sir. The impugned order merely relegates the petition, the respondent herein to the Board of Revenue for adjudication of the revision petition. That view of the matter, the court is not inclined to interfere with the impugned order, but leaves the contentions of the appellant state open to be urged in the said proceedings in accordance with law. The writ appeal is disposed of.
Item 77.
77 departmental promotion during pendency of departmental LRC fixed with 27th March.
All right.
Item 78.
May I please, my lord. My lord, may kindly see running page number 63, my lord. My lord, during the period of COVID-19, my lord, the appellant corporation floated a scheme called COVID-19 relief scheme, fixing the criteria, my lord, where the negative certificate of the COVID testing not available, claim of the a claim for dependent benefits even after 45 days shall be considered. But my lord, in page number 136, while the scheme was presented before the parliament, parliament modified the same and fixed in case where the date of recovery from COVID-19 cannot be ascertained for want of COVID-19 negative certificate, the post-COVID death up to 45 days after testing COVID positive shall be considered for relief under the scheme. My lord, the admittedly, the deceased husband of the respondent number 1 was an employee and died on 26 2021. Then the petitioner filed application for claiming the benefit under the scheme. The appellants rejected the claim of the respondent number 1 on the ground the death was occurred after 65 days, and the same is not coming under that restriction provided by the under the scheme. Assailing that rejection order, respondent number 1 filed writ application number WPC number 21400 of 22, which was disposed upon 10/1/23, and in paragraph 12 of the impugned order, my lord, the honorable single judge held that it is clear that the contingency sought to be addressed by this by subclause was the absence of negative certificate after having tested COVID positive and before death for the 45 days period to take effect as eligibility criteria of entitlement of to relief under the scheme. This guideline is not applicable in the in case of petitioner claiming relief, since though there was no negative certificate in respect of the deceased, but the death of the deceased was officially certified as due to COVID-19. My lord, while passing the impugned judgment, honorable single judge did not take note of the death certificate originally obtained. My lord, it is at page 54, my lord, where there is no mention of death due to COVID-19. Subsequently, that Annex 10 to the writ application at page page 121, it was obtained for the second time, and that was issued as per the guidelines of the Supreme Court.
But this does say it is due to COVID. Official document for COVID-19 deaths, it says.
My lord.
Then?
My lord, but restriction is not about death due to COVID-19. It was, there may be death after 2 months, 3 months, 4 months. So for restriction of the claim, the parliament fixed it up to death, death up to 45 days, where negative certificate is not available.
No, but in this case, an official document has been issued in favor of the respondent.
My lord, official document also page number
96, that is 121, your annexure 10.
My lord, so also annexure, a page number.
There is a presumption, official documents is a presumption of genuineness.
My lord, no, death is not disputed, my lord. Death is not disputed. Only question whether that restrictions are applicable or not.
Let's see the single judge, what the single judge says.
My lord. My lord, that page. Page 12, my lord, of the writ appeal, and relevant portion is at page 19, paragraph 12, my lord.
Yes.
It is clear that the contingency sought to be added by the subclause was the absence of negative certificate after having tested positive and before death for the 45 days period to take effect as eligibility criteria of entitlement of relief under the scheme. This guideline is not applicable in case of petitioner claiming the relief, since though there was no negative certificate in respect of the deceased, but the death of the deceased was officially certified as due to COVID-19.
Which is correct. It was officially certified as due to COVID-19. I just now showed you that certificate. It's correct only, sir. Nothing in the appeal. The present appeal is directed against a judgment dated 10 January 2023, passed by the single judge, disposing of writ petition civil 21400 of 2022, filed by the respondents, who are the legal representatives of one late Shri Sanjay Kumar Nayak, who died on 20 June 2021. So the prayer in the writ petition was for a direction to the Employees State Insurance Corporation to process the application made by the respondent writ petitioners for COVID-19 relief in terms of a scheme announced by the appellant. The stand of the ESI was that the guidelines provided for the death occurring in a period of 45 days after testing COVID-19 positive. Stop. The scheme was placed before Parliament under Section 97 of the ESI Act. It was argued that the ESI Corporation is bound by its own scheme. And that Shri Nayak did not fall within the parameters stipulated therein. Paragraph. It was pointed out before the learned single judge that para 11 bracket 1 bracket 3 bracket D of the notification dated 11th August 2021. Read as under. Take from pages 17, 18. 17 bottom, 18 top. Paragraph. The learned single judge has taken note of the official certificate issued which states that Shri Nayak died of COVID-19 on 20 June 2021. Full stop. Only because of the test report which stated that, which showed that he had tested positive in respect of a sample collected on 16th April 2021. It was, and the report was received on 13th October 2021 in respect of such sample, which was beyond the 45-day period after 20th June 2021. ESI declined to entertain the claim. Paragraph. In para 12 of the impugned order, it has been held as under by the learned single judge. Paragraph. Having heard learned counsel for the appellant, the court is of the view that the learned single judge has committed no error in the analysis of the clauses of the scheme and in the conclusion that rejection of the claim of the respondents was bad in law. There is no ground made out for interference. The writ appeal is dismissed.
May I make a small prayer, Millers? I am appearing for the respondent number 1 and 2. Since there is no time stipulated for compliance of the single judge order.
Now the order the learned single judge shall be complied within a period of 4 weeks.
My lord, there is a procedure and not on the simple saying the benefits are, there is a procedure. So fixing the time limit may be.
What will happen? The ESI corporation will shut down.
My lord?
The corporation will shut down, sir, if you specify a time limit.
Item 79.
All right.
Please, Your Lordship. The impugned order is under Annexure 9 passed by the Honorable Single Judge, my lord. And the sole grievance against the sole grievance of the petitioner is that, my lord, due to laxness and negligence committed on the part of the opposite parties, my lord, the petitioner has been penalized and 5% simple interest has been charged against the enhanced rate, my lord. Because why I am submitting, my lord? Because the decision taken on under Annexure 3, the ITCO authority to provide land, 1 acre land. They have allotted 1 acre land against the SSI unit of the petitioner in 4/2/2008, my lord, and directed to deposit 3,35,000. He has deposited. Thereafter, my lord, under Annexure 5, my lord, they have cancelled the said allotment. And in 5/8/2008, under Annexure 5. Again, my lord, under Annexure 6, in 2016, land has been allotted in favor of the petitioner, my lord, and that has been deferred under on 12/5/2016. Subsequently, under Annexure 7, they have fixed the enhanced rate in place of 3,35,000, 18 lakhs. The council was.
Where is the plot lying? Where is the plot, sir? Where is the plot in question?
My lord, the Annexure 3, my lord. They have allotted the land, 1 acre land.
Question was, where is this land?
That is, my lord, establishment fabrication at, my lord, KNIC, that is at, my lord, Jajpur, under Jajpur, my lord.
You're not familiar with the facts, sir. You don't even know where the land is.
I mentioned, my lord. That is, my lord, under Kalinganagar Industrial Complex, Duguri, Jajpur, for establishment of ancillary and downstream industries for the steel projects, my lord.
So it's an industrial complex land.
My lord. And my lord, my responsibility in 2008, I have deposited that has been cancelled. Thereafter, my lord, they have refunded after obtaining 10%, deducting 10%. My lord, in 2016, they have allotted and cancelled, deferred. But there is no fault of the petitioner. And again, my lord, 2017, they have allotted the land and by announced rate, that announced rate has not been challenged. By the kindly have a glance, running page, impugned order running page 35, my lord. So far as 5% simple interest charge, that is, my lord, my grievance. But I have not committed any fault. So, my lord, without they have under Annexure 7, my lord, they have demanded land cost 18 lakhs. I am not disputing.
What is this interest about work out to? 5% simple interest. What does it work out to? Nothing, sir. Nothing substantial. This is a 1 acre plot, right?
My lord.
Getting it for a song, sir.
My lord, that is without my fault, my lord.
To be realistic, sir. Getting valuable piece of land.
My lord, I admit, my lord, but that announced I am not disputing. I am ready, but without, my lord, they have demanded 18 lakhs. Again, my lord, imposing 5% interest, my lord.
What is 5%, sir? What is 5%? What will it work out to?
No, that is, my lord, without my fault, my lord.
All right. You see, under in terms of the impugned order, dated 24 January 2023, passed by the single judge disposing of the appellants. Writ petition civil 3126 of 2018. The appellant has been required to pay IDCO the balance sum towards allotment of a plot in a Jajpur industrial complex, together with 5% simple interest for the period of delay. The amounts already deposited by the petitioner have been asked to be adjusted in computing the balance amount. Paragraph. Having heard learned counsel for the appellant, the court is of the view that the learned single judge has adopted a balanced, equitable approach, and the impugned order suffers from no legal infirmity that calls for interference. The appeal is accordingly dismissed.
Item number 80.
Please, your lordship. This appeal is directed against the interim order of the Honorable Single Judge at Annexure 9, page 87. It starts from page 91, where the impugned order has been passed in gross contravention of the Odisha Fire Safety and Fire Prevention rules.
Land friend has to serve a copy, my lord.
I have served a copy on 9.
No, I have not received.
My lord, I have received this.
There is some development after this order.
Since 9th, I have served the copy. So, my lord, what has happened is that there is an apartment which is under construction apartment, and without obtaining fire clearance certificate from the fire department, a sale deed was executed and 45 persons have been given occupation of that apartment.
No, but there was a direction that the fire safety certificate should be granted within 1 month of 14/2/23.
They were to take a decision, but
today 1 month is over.
Yes, nothing has happened because it is incomplete. My grievance is at paragraph 4, where the occupiers have been left at their own risk.
No, what are you?
We are the landowners there, and we had given a power of attorney to the builder. Now, he, without completing the construction and without obtaining the fire certificate, which is required as per Rule 11 of the Odisha Fire Safety Rules, which says that no sale deed can be executed nor any occupation can be given. But he has executed sale deeds, he has given occupations. There are reports of the fire inspection team which says that the building is hazardous for a human occupation. They need to be immediately
But how are you affected?
Because, my lord, we will be held to be vicariously liable because they are just like our agents. We have given them the development agreement. to construct the flat.
So this is actually a breach of the development agreement.
Development agreement also.
So it must have an arbitration clause.
No, it doesn't have that. I've annexed. But
You have to file a suit, sir.
My concern is that.
Why do you file a writ petition?
My concern
Actually, you're trying to enforce a condition the contract against the builder.
Yes.
By filing a writ petition. That's what you're trying to do.
My concern is that there will be an immense loss of life due to this. The inspection reports.
Go for a regular suit.
Yes.
Go for a regular suit.
Yes, but only one.
We'll say notwithstanding the impugned order, you can still file a suit for breach of terms of contract.
Only I am agreed by paragraph 4, where it has been written that the occupiers will remain there at their own risk. Now, my lord, if there is any mishap, then their lives are at risk.
So this order will help you?
No,
obviously, we are trying that the liability will fall on you. The single judge's order says, no, it's at their risk.
And at
in
below,
fact, succeeded.
And at below para 1, it is.
Are you seriously wanting to challenge this order?
No, my lord, because at below at para 1, now it is self-contradictory. It says that there will be no handing over of possession of the buildings when the building possession has already been handed over. So, in fact, the impugned order is self-contradictory.
This is interim order.
Yes, your lordship.
So what is that to challenge this, sir?
Your lordship may see
the present writ appeal is against an interim order passed by the learned single judge on 14th February 2023, writ petition civil 4331 of 2023. Stating that there shall be a stay. What is Annexure 7?
Annexure 7 is at page 82 of my writ appeal, which is the an order by the fire department that
This is also Annexure 7 in the writ petition.
No, there it was. Yes, it was also there.
The same Annexure 7.
Same Annexure 7, directing to vacate the building by the fire
department. There should be a stay of the order issued, a letter dated 6/2/2023 issued by the fire department. Addressed to the builder.
Yes, your lordship.
So there is another writ petition 37014.
That was an earlier writ petition where the fire department was in fact directed, you complete these proceedings, the illegality which is going on. And the fire department came to the conclusion that the building is hazardous. Anytime any mishap may happen, you vacate it immediately. My lord, it is at page 82, this Annexure 7.
Directing the occupants to vacate the building under construction as it was unsafe from the point of view of the Odisha Fire Prevention and Fire Safety Rules 2017 as amended in 2019 paragraph. The learned single judge is, however, clarified in the impugned interim order that the occupiers would continue to do so at their own risk. Full stop. This, to a certain extent, answers the apprehension of the present appellants, the original owners, that if there is any mishap, they will be held liable. Full stop. With the learned single judge having shifted the risk to the occupiers themselves. It will be open to the appellants to urge, on the strength of the impugned interim order, that for any mishap occurring in the meanwhile, it is the occupiers themselves who will be at fault. Paragraph. Consequently, the court does not consider it necessary to interfere at this stage with the impugned interim order. The writ appeal is dismissed.
Only one relief I want. If in the meantime the application is rejected, let the department take action.
That's all in the interim. The writ petition, you can file that application and ask for that relief.
Yes, your lordship.
Right.
Item 81.
May I please yours? Well, I have challenged the order under Annexure 1 mirror, page 12. 8/9/2020 mirror. And this was in the first day disposal. Another thing, my lord, kindly turn to page 13. My lord, while disposing of, my lord, that said that it was a covered case of Mayadhar Pradhan and others. And
if you are agreeable, it can go back, sir. It's a first day disposal.
Milords, if your lordship sees the parent judgment that the honorable single judge has relied upon, I'll supply the copy.
Mayadar Pradhan.
Milords, that is the parent judgment.
Two appeals have been filed. There are two cases.
Milords, it is no more res integra that mere filing of an appeal will not operate as a stay. There is no stay order in that writ appeals, Milords. I again repeat, Milords, what has happened, relying on that parent judgment of Mayadar Pradhan, two other similar different RMCs, similar employees of similar footing have already been granted benefit of 6 pay commission. So
whether or not you're covered by that, still they have to file a reply at least.
Milords, may kindly have a perusal of this judgment of Mayadar Pradhan. It has touched the nuances of every provisions of the statute.
So whether you're covered by it or not, only when at least pleadings have to be completed for that at least. Let it go back, sir. The repetition.
Milords, this is anyway second round of litigation, Milords.
Why? There was a representation.
Milords.
That's hardly anything, sir. The impugned order dated 8 September 2022 passed by the learned single judge disposing of writ petition civil 19803 of 2020 has been passed on the very first day of hearing, without any opportunity to the present appellant to file a counter affidavit to the writ petition. Although counsel for the respondents argued that their case was covered by the decision dated 26 March 2019 of this court in writ petition civil 8608 of 2010, Mayadar Pradhan versus State of Orissa,
Milords, I just want to intervene, Milords. This is a matter of 2010 and it was passed in 2010. It is not that the opportunity was not given to them, Milords. It was the matter was of 2010.
No, was it not the first hearing?
No, Milords.
No, it's a 2020 matter. What are you saying?
Milords, the
page 12. Come to page 12. This is a writ petition of 2020, not 2010.
Milords, I am relying upon that parent judgment. Your lordship may then direct it. Milords.
Nevertheless, an opportunity ought to have been given to the present appellant to point out to the learned single judge by way of a counter affidavit whether or not the case of the respondent stood covered by the said judgment. Full stop. Paragraph. On the above short ground, the impugned order is hereby set aside, and the matter is and writ petition civil 19803 of 2020 is directed to be listed before the learned single judge for a fresh hearing on 3rd July 2023. The present appellant will file its reply to the writ petition positively on or before 26 June 2023. And the respondents herein, who are the writ petitioners, will file the rejoinder thereto before 3rd July 2023. No further time will be granted for this purpose. The learned single judge in the roster bench is requested to proceed with the hearing of the writ petition on merits and endeavor to dispose it of as expeditiously as possible.
But
the writ appeal is disposed of thereafter. The contempt petition, you say, in view of the order passed today in writ appeal 122 of 2021. The present contempt petition does not survive and is disposed of as such.
Item number 82.
Item number 82, my lords. There, my lords, kind of a glance, my lords, order dated 19 December 2022, my lords.
What happened, Mr. Do you have the guidelines now?
No, they have filed. The planning member CD has filed an affidavit.
I filed an affidavit, my lords, on behalf of planning member CDA, my lords.
Appearing for the CDA is submitted.
My lords, I filed an affidavit, my lords, on behalf of planning member CDA, my lords. My lords, they desire to know about the status of that particular regulation, my lords.
Yes.
My lords, para 3, we have received that regulation from the consultant on 8 February 2023. Now it is under scrutiny. And the whole total process should be completed by end of May. Then we'll go for advertisement as required under section 123 of the 125 of the ODR. We'll invite objection and suggestion matters by first week of May.
Copy should be given.
First week of June.
If they file an affidavit,
yes,
this will serve copy.
All right. Affidavit dated 9th March 2023 has been filed by the member, planning member,
My lords,
of
planning
Country
member.
Development Authority, bracket CDA, stating interior that the draft regulations prepared are under single quotes threadbare scrutiny and will be published in the Gazette under Section 125 of the Orissa Development Authority Act for inviting objections and suggestions in a time-bound manner. Mr. Mahapatra, learned counsel appearing for the CDA, submits that this entire process, including sending the draft to the government for its approval under Section 124 of the ODA Act, will be completed in the first week of May.
No, but first week of June, managers will bring our inviting objection and suggestion. Will bring that in the Gazette notification. That is my instruction.
No, but you better complete the whole process.
Whole total process, my lord, because thereafter it will go to the authority. Objection and suggestion will be considered by the authority.
By the end of June 2023. List on. Give me that. Yeah. 5th July. 5 July 5th.
So that interim order is there.
Yeah, interim orders to continue. Right.
So one thing you should observe, they should follow the guideline that was fixed on the basis of which they are granted.
Yeah, the court's guidelines. That's what we agreed.
Not following. Sometimes the municipality is actually deviating.
You'll have to bring that to our notice, then we can pass.
I'll get.
Right.
Item number 83.
Oh,
No, my lords, I may be permitted. My lords, I was late when the judgments were pronounced.
Oh, Justice Raman.
But I heard that it is in the favor of the SEC. So
subject to what will happen.
That is always.
That's right. That's right.
No, actually, it's a balanced judgment. Actually,
I know, but it all depends, sir. We learn every day. So,
thank you, Lordship.
Right.
Many.
Right.
Item 83.
Item 83, my lord. Just now, the OP number 4 has filed the counter affidavit, and OP number 1 also yesterday filed. So, quick time to take instruction or file any objection. I am for the petition.
we have filed the counter, my lord.
Just now, they served the
Filed earlier, a copy has been.
just now, served copy was served, my lord. So, it takes some time to go through it, my lord.
Amar counter tata. Government counter.
Government counter also yesterday they have served.
This is counter affidavit on behalf of Utkal Almina.
Yes. One counter affidavit has been filed on behalf of the Revenue Department.
When was that filed?
Yesterday it was filed.
OP number 4 has also filed a counter.
All right. On 5th March, an affidavit dated 5th March 2023 has been filed by opposite party number 4, Utkal Alumina International Limited, and a separate affidavit has been filed on 20th February 2023 by the Deputy Collector and in charge Special Land Acquisition Officer Ragada. Copies of the said affidavit be served on counsel of the petitioner.
Already served. My lord, yesterday I have filed also another affidavit. Revenue on behalf of the government. Joint Secretary.
A third affidavit stated to have been filed yesterday on behalf of the government be brought on record. Copies of the said affidavits be served on counsel of the petitioner, who is permitted to file a rejoinder thereto before the next date.
My lord, it is.
List on July.
5th July.
6th.
Item number 84.
Right, please, your lordship. My lord, item 84, on the last occasion, 28/11/2022, the Learned Council for the State has prayed for time to file a counter.
My lord, no need to file any counter. We have already complied. Potta has been corrected and I am giving the instruction. If it is already reverted back to the government khata.
Oh, yes. All right.
That is one of the prayers, your lordship. The other prayers for the eviction of that person from the land still remains, and I have made it a prayer in the writ also.
No, but what about actually evicting the person?
That has not been done.
Mr. Mahathir has handed over.
Yes.
A communication dated 14th March 2023 received from the office of the Tahsildar, Basudepur.
Along with the corrected record of rights.
Stating that the record of rights stand corrected and the land in question is reverted
to
the government khata number 1309 of Mausa Basudepur. Paragraph. Counsel for the petitioners, however, points out that the actually eviction of the encroachers has not taken place yet. On this aspect, a separate affidavit be filed by the Tahsildar Basudepur on or before 3rd July 2023, failing which the said Tahsildar will remain present virtually on the next date of
I will file it.
Virtual presence is nothing, sir.
No, I will
Man has to simply switch on one camera sitting in his office.
Your lordship is also saying failing which. Yes.
List on 18 July.
My lord, yes, copy may be served to me, your lordship.
Obviously. Sir.
He has to come here and take the copy.
There, your lordship. That is there, my associate is
Then I
there.
know.
He's been handed over a copy. All right.
Yes, your lordship.
Item 85.
Obliged, my lord.
Item number 85.
May is the next date. How come it's listed today? Achha, the correction be carried out as pointed out. All right. Right.
Item 86.
86, my lord, I'm seeking for an adjournment.
What's the matter about?
33 kV electric line is passing over a densely populated area which includes school premises.
Read. I am for the supplier open number 5 and 6. I have filed an additional affidavit to your lordship kindly glance.
My lord,
At flag
actually.
G. At flag G, your lordship.
1 minute.
The prayer is no more in force because of we have already provided power supply to OP9 company on 26/11/2021.
21.
We'll just
Here in
take-
this case, a group of people came to this annual court by filing a PIL in double PC number 9972 of 2019. And the OP9 company, he submitted a sketch map before this annual court that to divert that line so that the prayer of that densely populated area or school or to overriding all these facts. You'll also annex A/2 that counter affidavit filed by the company, OP9 company at page 24. They have diverted the lines in the green color mark. And on the basis, the writ petition 9972 was disposed of.
Okay.
After 48 days, these petitioners came to this annual another PIL to comply the order of this annual court in passed in double PC 9972 of 2019. And in the meantime, they have diverted that line in that green color mark and their power supply has been provided.
Let it come on another day. We'll just take instruction because
No, but
already
last time, I think already time was granted for rejoinder.
2-3 times time.
the old lady, like
It's all right,
she has
it's
to travel alone.
Can't endlessly. There's no question of traveling. These days,
50
there's no question of all
kilometers
that.
from here, my lord.
All right, already.
Let it come on next week. I'll take instruction on this.
Already 3 adjournments were granted. On
Just file and rejoinder.
21st March, 11 July and 16 November 2022 to enable the petitioners to file a rejoinder affidavit.
You just file and rejoinder
Despite
next week.
which till date, which is almost a year, no rejoinder has been filed. To stop counsel, the petitioner seeks one more adjournment, which does not appear to the court to be reasonable and therefore is rejected. Paragraph. The main grievance raised in the present petition by the is that there is a 33 kVA electric line which is running through a densely populated area, including school premises and reserve forest, thereby violating safety norms, and is also said to be in violation of the orders passed earlier by this court in Writ Petition Civil 9972 of 2019. Paragraph. It has been explained in the counter affidavit filed on behalf of the opposite party number 9 company, for whose benefit the said 33 kVA line has been laid, that pursuant to the orders passed by this court on 29th January 2020 in Writ Petition Civil 9972 of 2019. The line itself has been diverted. The 33 kVA line has been diverted and is now bypassing the densely populated Jurudi Basti, UGME School and SJ High School, Jurudi, as well as the Bame Bal High School. Full stop. Copy of the diversion proposal has been enclosed with the said affidavit. Paragraph. This has been confirmed by the additional affidavit filed by the executive engineer, PPNODL, who has confirmed that the said line, which is on the as per the which has been erected as per the above diversion proposal, has already been energized on 26 November 2021 itself, and that the entire arrangement is without any difficulty being caused to any of the inhabitants in the area. Paragraph. In view of the above development, no further directions are called for in the present petition and just disposed of this action.
Item number 87. There is a noting that respondent number 5 could not be located. Therefore, I will find out the correct address where she is residing and we will take fresh notice. The notice given in his appeal memorandum, I took the notice, my lord, as per given by her.
All right. Counsel for the appellant states that he will have respondent 5 served through substituted service.
Substituted service, my lord, that is paper publication. The Anganwadi worker, my lord, got
Or not. The Anganwadi worker has so much litigating capacity.
no gets only
They
my
don't
lord
stop litigation, they file writ appeal.
8,000 per month, my lord.
That is okay, but it appears that they have a lot of
paper
litigating
publication,
capacity.
it will be around 15,000, 16,000.
Whatever,
my lord.
sir.
2 months salary. I will find out the correct address within 1 week. I will take the notice by this.
All right. Then take this off. This is counsel. The appellant states that he will ascertain the present correct address of respondent 5 and file it in the registry within 2 weeks. Thereafter, fresh notice on the current address will be issued to respondent 5 returnable on 18 July.
Interim order may continue.
Interim order to continue.
Obligement. Item number 88.
My lord, I seek 1 week time because I have to prepare and get chart, my lord. Is the case where rehabilitation appointment, the single judge is directed to give rehabilitation appointment up to 22 years. A. B. There is a scheme governing the field, my lord.
All right.
And the
Mr. Mishra, senior advocate, seeks time to file a list of dates and events and note of submissions.
Obliged.
It be done within 4 weeks. Likewise, the respondent is also permitted to do likewise before the next date. List on 21st August.
Interim order to continue now.
Yeah, interim order to continue.
Obliged.
Item number 89.
Addressee cannot be located.
In item 89, my lord.
Addressee cannot be located.
Respond number 1.
AD not back. 2 has entered appearance. 3 again undelivered. Who's appearing for respondent number 2?
I am appearing for the respondent number 2. Either in the petition nor in the writ appeal, there is any relief sought against respondent number 2.
I see.
So respond number 1, in fact, respond number 1 is the affected party. I'll take fresh notice.
The AD card has not been received from respondent number 1. Stop. Counsel appearing for respondent number 2 states that no relief is being sought against the said party. Notice to respondent number 3 also has been returned unserved, saying single quotes addressee cannot be located.
In
fact, the appellant will ascertain the correct present addresses of respondents 1 and 3.
But 3 is only formal party, only.
All right. Counsel for the appellant states that respondent number 3 is only a formal party and therefore it will be deleted from the area of parties. They said prayer is accepted. The consolidated memo of parties be filed within a week. The correct present address of respondent number 1 be furnished to the registry within 2 weeks. Thereafter, fresh notice to respondent number 1 returnable on.
My lord, may I submit, my lord? May I serve a copy on Mr. Counsel who has
21st August. Additionally, counsel for the appellant is permitted to serve
a copy of the writ appeal.
Copy of the writ appeal on the counsel who appeared for respondent number 1 before the single judge. All right. Interim order to continue. List on 21st August.
Item number 90.
May I please allow, sir?
Item 90, I am filing objection to the limitation petition, Lordship.
What's the delay?
Lord, 90 days. I have given
COVID period.
COVID period. It says during summer vacation.
For the reason stated, the delay is condoned. What is this first?
Lordship, we have ground to challenge on limitation point, Lordship.
Supreme Court orders has all this COVID times.
Lordship, that is not in COVID period, Lordship.
Why? What's the implement order date?
During the summer vacation of 2022, and I have given the of the concerned person because which illicit could not have duly explained.
Lordship, prior to the medical certificate, that is 60 days period, Lordship. And it's a company that is constituted with 4 directors, Lordship.
All right. What's the impugn order?
Lord, impugn order is at phase, my lord.
Lordship, appeal memo has not been sought to us, Lordship.
My lord, everything has been sent by notice.
Only we have received notice on limitation point, Lordship.
All right. The writ appeal, you say copy of the writ appeal be served on counsel for the respondent during the course of the day. Interim order to continue.
There is no interim order, Lordship.
MSME proceeding has been quashed, my lord. MSME proceeding under the MSME Development Act. Arbitration proceedings.
21st August. All right.
May I play a short date, my lord, that it's an MSME and he is being deprived of its dues, my lord. I play a shorter date, my lord. And it's covered by your lordship's decision of that Delhi High Court decision, my lord.
All right. 10th August. All right. Well.
Past door matter. Supplementary list, past door matter, item number 17. Item 17.
None appears despite a password. Dismissed on opposite.
Item number 26.
As 26, I may be allowed to withdraw with liberty to file review petition. 26.
Liberty to file?
A review petition.
Grateful. This is withdrawn, liberty file review petition.
Item number 53.
Please, please. Item 53. Well, here the respondent is the wife of the employee who's now deceased. So they had approached the court.
Rehabilitation assistance.
No, this is family pension. Now, the employee was dismissed because he was convicted under the NDPS Act. He had filed an appeal, but unfortunately, since he expired
So the
2017,
conviction remains.
yes, Milords, the conviction remains. So therefore, under Rule 33, Milords,
They could have asked to continue the appeal if they were so keen. They could have asked to continue the appeal actually.
this is the first day disposal also. So we could,
First day disposal. Oh, that's okay. Notice returnable. 3rd May. There should be a stay of impugn order. All right.
Item number 62.
The 62 is Milords Sarath Parida case, so 8th of
8th May. All right.
Late fee.
Item number 63.
63, my lord, order of honorable single judge had been implemented. So that may be enforced.
Counsel to the appellant informs the court that the impugned order of the single judge has been implemented. The appeal is disposed of as having become the